Real Estate Principles. Unit 15. Government Control of Land Use, Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Identify the ways in which the police power of government is used to regulate land use. List the required provisions of a general plan. State the purpose of a community redevelopment agency. Identify the two major subdivision laws and state the purpose of each. Describe the forms of common interest subdivisions. Explain the federal and state fair housing laws and how they apply to real estate practice. Key terms. Accessory dwelling unit. City planning. Civil Rights Act of 1866. Civil Rights Housing Act of 2006. Coastal zone. Commercial acre. Common interest. Subdivision community. Apartment project community. Redevelopment agency CRA. Condemnation. Conditional use permit. Department of Fair Employment and Housing. Earthquake fault zone. Eminent domain. Environmental Impact Report EIR. Fair Employment and Housing Act FEHA. Fair Housing Act. Form-based planning. General plan. Housing Financial Discrimination Act. Adverse condemnation. Jones versus Mayor. Equity Housing Cooperative. Master plan. Mortgage revenue bonds. Negative declaration. Non-conforming use. Parcel map. Planned development. Planned unit development PUD. Report redlining. Rezoning. Seismic hazards. Zone standard. Subdivision. Subdivided lands. Law subdivision. Map subdivision. Map Act tax. Increment funding. Timeshare project. Undivided interest. UNRRA Civil Rights Act. Zones. Zoning. Zoning ordinances. Zoning variants. Land use regulations. Government controls land use, in some cases taking over ownership of the land in four main ways that can be remembered by the acronym PEAT. Police power, eminent domain, taxation, sheet. The government's power of taxation is discussed in Unit 11, and the government's power of escheat is discussed in Unit 4. This unit considers the government's permitted activities under its police power and its right of eminent domain. Police power and eminent domain. Land use controls are possible because of the government's police power. This power enables government bodies to regulate private activity by enacting laws that benefit the public health, safety, and general welfare. As a general rule, the owner of property is not compensated for any loss in property value that results from the government's exercise of its police power. Building codes and other criteria establish standards for safe housing. Additional government regulations control of the use of real estate. Information on many California cities can be found at the site of the League of California Cities, www.cacities.org. The most useful municipal sites, such as that of the City of San Diego, provide the city's charter, municipal code, agendas, and other information. Taking a property by condemnation requires compensation to the property owner. The government also may take all or some of the rights of ownership from private individuals by exercising its power of eminent domain. The government does compensate individuals when property is taken through the process called condemnation, as when buildings are torn down to make way for highway expansion. The fair market value of the real estate is paid to compensate the willing or unwilling former owner. When only part of a property is taken, compensation generally is based on the difference between the value of the entire parcel before the taking and the value of the remaining part. For example, agricultural land zoned for residential use is purchased for development. The purchase price is much greater than it would be for land zoned for strictly agricultural use. The land then is rezoned to strictly agricultural use before the development begins. Should the landowner be compensated for the loss in market value caused by the change in zoning classification? At present, the answer to that question is no unless the property owner is denied all reasonable use of the property. The U.S. Supreme Court is called on to consider such cases frequently, however, and eventually may decide that loss in land value resulting from any change in use is a taking and must be compensated. City planning. When an area is first settled, there usually is abundant land for all purposes. Planning for the use of the land may be considered an unnecessary burden on development. At a certain point, however, there is demand from all sectors of society on ever scarcer land and resources. City planning then becomes a useful tool to help ensure orderly, sensible growth and development. Early city plans in California include that of the city of Paso Robles in San Luis Obispo County, which was planned in the late 1860s by Drury Woodson James. A modern example is the city of Irvine, in Orange County, created on what was the 53,000-acre Irvine Ranch. Since the 1960s, the Irvine Company has developed residential and business areas within the city and has even donated land for what is now the campus of the University of California at Irvine. More recently, development of the inland valleys has seen the creation of many new planned communities. The General Plan. The Government Code requires that every general plan include provision for the following: land use, including standards of population density and building intensity; circulation, including distribution of transportation facilities and public utilities; housing at all income levels; conservation of natural resources; open space to preserve natural resources in light of recreational needs and public health and safety; noise problems, both existing and foreseeable; safety from fire, seismic, earthquake, and geological hazards. The General Plan. Where applicable, the General Plan also provides for coastal development, protection of mineral and forestry resources, and development within seismic zones. The plan also may include local areas of concern, such as historic preservation. Since 1982, counties have been required to have a solid waste management plan consistent with the county's general plan. Finally, every county with a public airport served by a certified air carrier has an Airport Land Use Commission that must prepare an airport land use plan that is consistent with the general plan, unless a specific exception is allowed. Every city and county within California now is required by state law to adopt a comprehensive, long-term general plan for development within its jurisdiction. Community development goals are set out in the general plan. The general plan, also referred to as the master plan, is both a statement of policy and a means to enact that policy. It usually includes background information on the area economy, its development, population growth, and existing land uses. It states the goals and policies determining future development and gives one or more maps showing population distribution and designated land use areas and density. In addition, the general plan presents a program designed to implement the stated policy. The local planning commission, required by state law for counties but optional for cities, formulates the general plan, which then is adopted by resolution of the legislative body. Form-based planning. Assembly Bill 1268, signed into law in July 2004, is an outgrowth of the White Paper on Smart Growth Policy in California, prepared for the Governor's Office of Planning and Research in February 2003. The new law expands on the traditional system of planning to allow a concept called form-based planning. In traditional planning, different specialists working apart from one another design separate components of the urban landscape, often leading to isolated land use areas and sprawl. Form-based planning provides for a mix of land uses, while taking into account the relationship of buildings and public areas, resulting in a much more pedestrian-friendly urban environment. Procedure for adoption. The Government Code outlines the procedure for adoption of a general plan or an amendment to the general plan. If the jurisdiction has a planning commission, a public hearing is held before that group, and a majority of planning commissioners must vote in favor of the plan. Then another public hearing is held by the local governing body, city council, or county board of supervisors, which can adopt the plan or amendment by resolution. The specific plan. A specific plan can be formulated after a general plan has been adopted. The specific plan may be so detailed that no further land use regulations, such as zoning, are required. In the specific plan, further attention is given to population growth, as well as environmental, economic, and other considerations in particular areas. locations of streets and utilities, projected population density, building construction requirements and topographical information, terrain and physical features can be provided. Zoning is the primary method of regulating property use. Zoning. Zoning is the dividing of a city into areas or zones limited to certain land uses, building requirements, or both. Zoning is the primary device for controlling land use and the principal tool for implementing the general plan. Zoning is authorized by the California Constitution as an exercise of a city's police power. It must be consistent with the policies and long-range goals of the general plan. If there is a conflict, the general plan takes precedence over zoning. The state has established a procedure for citizen complaints regarding non-compliance with the general plan. Zoning. Zoning specifications. Zoning ordinances typically cover permitted uses, minimum parcel size, building height limitations, lot coverage limitations, required setbacks, and maximum density. A zoning ordinance also typically provides for a conditional use permit that allows a non-conforming use, such as a church in a residential zone. An already existing use that does not conform to the current zoning may be grandfathered in and allowed to remain. Zoning changes. The overall designated land use may be changed in the process called rezoning. A zoning variance permits a change in the specifications required by the zoning ordinance if a property owner is placed at a disadvantage by the prescribed zoning specifications. State law permits a zoning variance where the strict application of the zoning ordinance deprives such property of privileges enjoyed by other property in the vicinity and under identical zoning classification. To expedite routine applications for permits, variances, and appeals, many jurisdictions have a zoning administrator, zoning board, or board of zoning adjustment. For example, the L family owns a home in 100 Oaks and would like to build a deck behind their home. Because of the unusual configuration of their hillside lot, their home is closer to the rear property line than other homes in the subdivision. A deck similar in size to the ones built by their neighbors would violate the local zoning ordinance by being too close to the rear boundary line. What can the L family do? The L family can seek a variance to the zoning ordinance to allow their backyard deck to be built closer to the rear lot line than the minimum setback stated in the ordinance. Because they are asking only to be allowed to enjoy their property in the same way that neighboring property owners are able to enjoy theirs, the L family most likely will be allowed a variance. Planned development. The planned development or planned unit development, PUD, is both a type of development and a zoning classification. A PUD usually allows individually owned residential property together with shared common areas. PUDs also may include commercial uses, industrial uses, or both. Planning and zoning law. The urgent need for additional affordable housing in California led to passage in 2021 of the planning and zoning law to provide for the creation of accessory dwelling units, ADUs. The law is designed to encourage creation of additional living spaces on property previously limited to single-family housing. The law provides for the creation of ADUs by local ordinance, or if a local agency has not adopted an ordinance, by ministerial approval in compliance with specified standards and conditions. The law, found in the government code, gives specific requirements for unit and parcel sizes and setbacks. Exercise. Why should the following factors be taken into account in formulating a general plan or a newly incorporated suburban city? Proximity, 20 miles to city of 2 million population. County plan encouraging commercial development. No growth initiative passed by voters of a neighboring city. Generally hilly terrain with past mudslide problems. Subdivisions. Most land development involves the subdividing of a parcel of land for the purpose of sale, lease, or financing. Controlled land development is important, and subdivisions often involve sales to consumers. For these reasons, there are two laws that specifically govern planning, design, site preparation, construction of improvements, and sales of subdivision land known as the following. Subdivided Lands Law. Subdivision Map Act. An overview of the subdivision process is provided in a guide to understanding residential subdivisions in California prepared by DRE, along with California State University, Sacramento in 2014. Subdivided Lands Law. The Subdivided Lands Law, found in the Business and Professions Code, describes the forms of ownership allowed in a subdivision of 5 or more parcels on up to 160 acres of land. The Subdivided Lands Law is administered by the Real Estate Commissioner. Its objective is to protect purchasers of property in new subdivisions from fraud, misrepresentation, or deceit in the marketing of the property. The Subdivided Lands Law also regulates the marketing and financing of the subdivision at the state level. For purposes of this law, the different parcels do not need to be adjacent or contiguous, touching. Details of any subdivision offered for sale in California must be submitted to the Real Estate Commissioner, who prepares and issues a subdivision public report describing the property. Before issuing the report, the Commissioner also receives information on the project's financial status. This is primarily to make sure that improvements to the land will be made as promised to purchasers. Types of subdivisions. The 3 basic types of subdivisions are the standard subdivision, common interest subdivision, and undivided interest subdivision. Standard subdivision. In the standard subdivision, the owners of separate parcels have no shared interest in any part of the subdivided land. Subdivision lots can be sold unimproved, but with utilities installed, to individual owners or developers for building purposes. Subdivision lots also can be fully improved with completed homes and offered with or without seller-arranged financing. If land is divided into parcels of 160 acres or more, it is not considered a subdivision as defined by the law. There is an exception to this general rule, however. If land is divided for sale for oil and gas purposes, it will be considered a subdivision no matter how large the individual parcels are. Common interest subdivision. In the common interest subdivision, a separate ownership or leasehold interest in a parcel is accompanied by a shared interest in what are called the common areas of the subdivision. The common areas usually are governed by a homeowners association. Some of the different forms of common interest subdivisions are summarized in the next box. An important addition to the Common Interest Development Open Meeting Act took effect January 1st, 2008. Civil Code 1363.05i requires that the agenda of any meeting of a homeowners association board be posted at least 4 days before the meeting. The law formerly required that notice of an upcoming meeting be given at least 4 days in advance of the meeting, but there was no requirement that the meeting agenda be posted in advance. Now, the law provides that if an item of business does not appear on an agenda posted at least 4 days in advance of the meeting, the board cannot discuss it. A non-agenda item can be brought up only if it concerns an emergency, as designated by a vote of a majority of the board, in which case it can be discussed and voted on. An item that a member speaks on in an open forum, in which case the board can answer questions. A clarification, announcement, or report on an ongoing activity or a matter that the board refers to the property manager or a member of the manager's staff for action, or for a report back to the board at a future meeting. The law is clear that an emergency exists only if a majority of the board of directors present at the meeting determines that there are circumstances that could not have been reasonably foreseen by the board that require immediate attention and possible action by the board, and that of necessity make it impracticable to provide notice, and the board is not free to discuss and or vote on a non-agenda item just because a member brings it up in an open forum. The board can answer questions but must schedule discussion of the item for a future meeting. Planned development. A planned development consists of individually owned parcels or lots as well as areas owned in common. A community apartment project. A community apartment project is one in which the owner has an undivided interest in the land and exclusive right of occupancy of an apartment on the land. All owners are tenants in common. The project will receive one tax bill and any loan will be on the entire project and the responsibility of all tenants. The condominium project. The owner of a condominium has an exclusive ownership interest in the airspace of a particular portion of real property, as well as an interest in common in the land and structure. The condominium form of ownership has been used for apartments, offices, stores, and industrial space. A condominium can be purchased and financed like any other real property. Stock cooperative project. Most stock cooperatives are apartment buildings. Each owner in a stock cooperative project is a shareholder in a corporation that holds title to the property, and the individual shareholders receive a right of exclusive occupancy of a portion of the property. Limited equity housing cooperative. A limited equity housing cooperative is a stock cooperative financed by the California Housing Finance Agency. Timeshare project. The latest type of primarily vacation use property is the timeshare. In a timeshare project, a purchaser receives the right to exclusive use of a portion of the property for a particular period of time each year, in perpetuity or for a certain number of years. There must be 12 or more separate interests before the project will be subject to California Department of Real Estate regulation. A timeshare estate includes an estate interest in the property, but a timeshare use does not. Timeshare properties range from city apartments to campground spaces. There is a 7-day right to rescind an offer to purchase a timeshare. Timeshare plan development is subject to the Vacation Ownership and Timeshare Act of 2004, as amended in 2005. Undivided interest subdivision. In an undivided interest subdivision, each owner is a tenant in common with all other owners. Each has the non-exclusive right to the use and occupancy of the property. An example of an undivided interest subdivision is a campground with shared facilities. The Subdivision Public Report. Subdivisions must meet the requirements of the Subdivided Lands Law before the Real Estate Commissioner will issue the necessary public report. All prospective purchasers must be given a copy of the report and be allowed to read it. In general, a notice of intention, a questionnaire, and an application must be filed. After a notice of intention has been filed or a public report has been made, any material change involving the subdivision must be reported to the Commissioner. Examples of material changes include changes to lot size, deed restrictions, or financing terms. The report requirements are stricter for common interest subdivisions, such as condominiums, than for standard subdivisions. The public report for a standard residential subdivision usually discloses the following: project name, location, and size, subdivider's name, interest to be acquired by purchaser or leasee, procedure for handling all payments, taxes, and assessments, extraordinary expenses at closing or expected in the future, hazards or adverse environmental factors, all conditions or restrictions on use of the property, unusual easements, rights of way, or setbacks, special building permit requirements. False or misleading advertising is always prohibited. Guidelines for advertising or promoting a subdivision are provided in the Commissioner's regulations. False or misleading advertising of any type is prohibited, regardless of whether it is specifically mentioned in the regulations. Because the public report may take months to compile, the subdivider may begin taking reservations for future purchases on the basis of an approved conditional public report. No sales can be closed or transactions completed, however, until the final public report is received. All persons who make a property reservation agreement based on a conditional report or who make an offer to purchase based on a final public report must indicate in writing that they have received and read the applicable report. The signed receipt must be in the form required by the Commissioner's regulations. The subdivider must make the receipt available for inspection by the Commissioner for 3 years from the date it is signed. Renewal. If all parcels have not been sold within 5 years of issuance of a final public report, it can be renewed for an additional 5 years. Right to negotiate property inspections. The public report for a residential subdivision must disclose that a prospective buyer has the right to negotiate with the seller to permit inspections of the property by the buyer, or someone designated by the buyer under terms mutually agreeable to buyer and seller. Business and Professions Code 1101 0.11. Filing fees. The Subdivided Lands Law sets maximum filing fees, but the Commissioner can charge less if administrative costs warrant it. Subdivision Map Act. The Subdivision Map Act, found in the Government Code, establishes a statewide procedure for filing a subdivision plan when property is divided into 2 or more parcels. The different parcels generally must be contiguous, touching. The Subdivision Map Act is an enabling act. This means that it authorizes cities and counties to establish subdivision requirements by local ordinance. Its purpose is to give local governments direct control of all physical aspects of a subdivision, such as lot design, placement of streets and sewers, and so on. Although the Act makes some procedural and other requirements, much of the content of the subdivision map will be dictated by the local authority. Subdivision Map Act. The twofold objectives of the Subdivision Map Act are to coordinate subdivision design, including streets and utilities, with the general plan, and to ensure that areas of a subdivision dedicated to public use, such as public streets, will be properly improved initially. The subdivision map must take into account much more than just parcel division lines and street locations. The Subdivision Map Act provides for tentative, final, and parcel maps for most subdivisions. Tentative map. The initial map is called the tentative subdivision map. It does not need to be based on a final, detailed survey of the property to be subdivided, unless that is required by local ordinance. A survey prepared by a registered civil engineer or licensed surveyor is always useful, however. The tentative map typically is required by local ordinance to include the following: legal description, including property boundaries of land and all parcels, widths and names of all existing streets, proposed street widths and grades and public areas, existing and proposed road, drainage, sewer, and other utility easements, source of water supply, storm water overflow and direction and flow of all watercourses, proposed property use. The developer subdivider is generally responsible for installing streets, curbs, and public utilities, and the government is responsible for maintaining them. From the developer's perspective, the most important consideration is the land remaining after accounting for streets, sidewalks, curbs, and so on. A commercial acre is the portion of an acre remaining after deducting the area required for streets and other improvements. Final map. Requirements specified by local ordinance must be met in preparing the final map. In addition, the Subdivision Map Act specifies certain requirements for a final subdivision map, beginning with the color of ink black and size of paper 18 by 26 inches to be used. Each parcel must be numbered, each block must be numbered or lettered, and each street must be named. The exact boundaries of the land must be shown. All soils reports are to be made part of the public record. If the subdivision will interfere with full and complete use of rights of way, easements, or other interests held by a public entity or public utility, the public entity or utility must be notified of the subdivision formation and given a chance to oppose it. A dedication or offer to dedicate any part of the land for public purposes must be made by a certificate signed by all parties having an interest of record in the land. Compliance with state law creates a statutory dedication. The clerk of each approving legislative body signs a certificate of execution indicating the acceptance or rejection of such dedicated property. The engineer or surveyor responsible for the map also signs a certificate that the survey is true and complete as shown. Other certificates also may be required. If the property is within an unincorporated area, the county surveyor and, if applicable, the city engineer must certify that the map is technically correct and conforms to both the law and the tentative map. Both state and local rules must be followed in preparing a subdivision map. Parcel map. Preparation of a parcel map may be waived by local ordinance. If not, the parcel map must meet both state and local requirements. The paper and ink specifications noted above also apply to parcel maps. Each parcel must be designated and all property boundaries shown. The subdivider must sign and acknowledge the parcel map by certificate. The engineer or surveyor conducting the field survey and preparing the map must certify its accuracy. Procedure for subdivision map approval. Approval of the subdivision map is the responsibility of the advisory agency designated by the city or county. Typically, this is the Planning Commission, but it could be any other official or official body so designated, such as the City Council or a committee of city officials. There are notice, hearing, time limitation, and other requirements involved in the subdivision map approval process. Notice and opportunity for hearing are required only when a map approval would constitute a significant deprivation of other landowners' property rights. The better practice, however, is to give notice and an opportunity for hearing before any subdivision approval. Approval of the tentative map requires that it conform to the general or specific plan, as well as to local ordinances or actions regarding housing needs. It also must meet requirements for future passive or natural heating or cooling opportunities. The site must be physically suitable for the proposed use and not likely to cause substantial environmental damage or serious public health problems. The final map must be filed before the tentative map expires, which is 2 years after its approval or conditional approval, 3 years for maps approved before May 16, 1996, plus any extension granted, with the total time not to exceed 5 years. The final map must be in substantial compliance with the tentative map. Local ordinances determine the approval procedure, but notice and an opportunity for hearing must be given to adjoining property owners if the subdivision will result in significant deprivation of their property rights. Other subdivision requirements. Environmental impact report. An Environmental Impact Report EIR authorized by the California Environmental Quality Act of 1970, CEQA, may be required before subdivision approval. CEQA requires any government agency that must approve a project, which may include the real estate commissioner as well as a local governing body, to prepare an EIR if the project will have a significant effect on the environment. Subdivision approval must be denied if the design of either the project or its improvements is likely to cause substantial environmental damage or substantially injure fish or wildlife or their habitat. CEQA requires an EIR or negative declaration. It is in the best interest of a subdivision developer to determine whether an EIR is necessary even before a tentative subdivision map is prepared. The government agency is authorized to issue a negative declaration, a statement that there will be no impact on the environment significant enough to warrant preparation of an EIR, if that is the case. Alquist-Priolo Earthquake Fault Zoning Act. The Alquist-Priolo Earthquake Fault Zoning Act, formerly called the Alquist-Priolo Special Studies Zones Act, regulates development in earthquake fault areas. It is concerned solely with possible damage from fault ruptures rather than from seismic, shaking effects. A geologic report must be obtained by local government for any new project initiated after May 4, 1975, involving improvements or structures in an earthquake fault zone, typically within a quarter of a mile or more of an active fault. If there are no undue hazards, the city or county can waive the report if the state geologist approves. Any agent or a seller acting without an agent of real estate located within an earthquake fault zone identified as such in a reasonably available map must disclose that fact to any prospective buyer. California Geological Survey maps of earthquake fault zones can be obtained from one of the California Department of Conservation offices in Los Angeles, Menlo Park, and Sacramento. The Seismic Hazards Mapping Act requires the same type of disclosure for property located in a seismic hazard zone if a map of the property's area is reasonably available. A map of the San Francisco area was released in 1995, with maps covering the rest of the state due for release over the next several years. California Coastal Act. The California Coastal Act defines coastal zones, which generally run the length of the state from the sea inland 1,000 or more yards, depending on terrain. The California Coastal Management Program authorizes local governments to make policies providing for coastal conservation and to require permits from developers of such property or owners. Rangeland, Grazing Land, and Grassland Protection Act. The Rangeland, Grazing Land, and Grassland Protection Act has established a program that provides grants for acquisition of conservation easements to protect, restore, or enhance California's rangeland, grazing land, and grasslands. Procedures and criteria for awarding of grants can be found in Division 10.4 of the California Public Resources Code. Water conservation. California law prohibits a city, including a charter city, county, or city and county, from enacting any new or enforcing any existing ordinance or regulation that prohibits the installation of drought-tolerant landscaping, synthetic grass, or artificial turf on residential property. The governing body may impose reasonable restrictions on the type of drought-tolerant landscaping, synthetic grass, or artificial turf that may be installed on residential property, provided that those restrictions do not substantially increase the cost, effectively prohibit the installation, or significantly impede the installation of drought-tolerant landscaping. Fair housing laws. Both the federal and the state governments have passed legislation to prohibit housing discrimination. This issue is so important, it is a mandatory subject of study for real estate license renewal. Discrimination in housing. Owners of housing are not to discriminate in the sale, rental, or lease of their property. Real estate brokers should not accept the listing of any property where such discrimination is attempted. Real estate property owners, brokers, salespeople, lenders, landlords, and hotel keepers are held to the same standard of conduct expected of all ethical citizens and professionals. Arbitrary discrimination, particularly in supplying housing, is strictly forbidden by both federal and state law. Federal law. The Civil Rights Act of 1866 prohibits racial discrimination in every property transaction. Although long ignored, the 1866 Civil Rights Act was upheld in 1968 by the U.S. Supreme Court in the case of Jones v. Mayer. The court found a constitutional basis for the 1866 Act in the 13th Amendment to the U.S. Constitution prohibiting slavery. A private individual may file a lawsuit in federal court alleging discrimination under the 1866 Civil Rights Act. Shortly before the Supreme Court decision in Jones v. Mayer, Congress enacted the Federal Fair Housing Act, Title 8 of the Civil Rights Act of 1968, based on the goal of fair housing throughout the United States. As since amended, it prohibits discrimination based on race, color, religion, sex, national origin, ancestry, handicap, familial status, federal law. The Civil Rights Act of 1866 prohibits racial discrimination in every property transaction. Although long ignored, the 1866 Civil Rights Act was upheld in 1968 by the U.S. Supreme Court in the case of Jones v. Mayer. The court found a constitutional basis for the 1866 Act in the 13th Amendment to the U.S. Constitution prohibiting slavery. A private individual may file a lawsuit in federal court alleging discrimination under the 1866 Civil Rights Act. Shortly before the Supreme Court decision in Jones v. Mayer, Congress enacted the Federal Fair Housing Act, Title 8 of the Civil Rights Act of 1968, based on the goal of fair housing throughout the United States. As since amended, it prohibits discrimination based on race, color, religion, sex, national origin, ancestry, handicap, familial status. The Federal Fair Housing Act applies to a sale or lease of residential property, as well as to advertising, lending, real estate brokerage activities, and other services related to residential transactions. It is enforceable by individuals, the Department of Housing and Urban Development, HUD, and the U.S. Attorney General. An individual has 1 year in which to file a complaint alleging discrimination with HUD's Office of Equal Opportunity, OEO, or 2 years in which to file a lawsuit in federal or state court. Both steps also could be taken within the separate deadlines. Some properties are exempt from the prohibitions against discrimination based on familial status, households with children under the age of 18. The Act exempts adult communities provided that all residents are age 62 or older, or at least 80% of the units are occupied by people age 55 or older. Some transactions exempt from the Federal Fair Housing Act include those involving preference to members of religious organizations or societies or affiliated nonprofit organizations when dealing with their own property, and as long as membership is not restricted on the basis of race, color, or national origin, and preference or limitation to members of private clubs with lodgings that are not open to the public and are not operated for a commercial purpose. No one is exempt from the 1866 Civil Rights Act that forbids racial discrimination. Also exempt are transactions involving a single-family home sold or rented by its owner if the owner owns no more than 3 such homes, or the rental of a room or unit in an owner-occupied dwelling of up to 4 units. Despite these exemptions, the property owner still would be subject to the 1866 Civil Rights Act. Also, being exempt from the Federal Fair Housing Act does not serve as an exemption from state law. State law. California's prohibitions against discrimination generally have been broader than the federal government's. In addition, local jurisdictions have passed a variety of anti-discrimination ordinances aimed at offering the widest housing choice to every resident of the state. California's Fair Employment and Housing Act, FEHA, formerly the Rumford Fair Housing Act, is enforced by the California Department of Fair Employment and Housing, DFEH. The Act prohibits discrimination in employment, training, or compensation based on race, religion, creed, color, national origin, ancestry, physical or mental disability, medical condition, genetic information, marital status, sex, gender, gender identity, gender expression, age, or sexual orientation of any person, Government Code Section 12940. FEHA prohibits discrimination or harassment in all aspects of housing, including sale, rental, lease, or financing, against any person because of the race, color, religion, sex, gender, gender identity, gender expression, sexual orientation, marital status, national origin, ancestry, familial status, source of income, disability, or genetic information of that person, Government Code Section 12955. Housing that meets the legal definition of senior housing for older persons under federal or state law is exempt from the familial status provisions of FEHA. Examples of discrimination include refusal to show property and arbitrary financing requirements. An individual may file a complaint alleging discrimination with the California Department of Fair Employment and Housing. Department of Fair Employment and Housing. The Civil Rights Housing Act of 2006, AB 2800, which took effect January 1, 2007, extends the protected classifications of the Fair Employment and Housing Act to all California laws prohibiting discrimination in housing and related areas, including real estate licensure and mortgage lending. Membership in clubs established by condominium homeowner associations and mobile home parks, development projects, and community redevelopment. In addition, whenever additional protected classes are added to the Fair Employment and Housing Act, the other non-discrimination laws will also be updated automatically. UNRRA Civil Rights Act prohibits discrimination in accommodations and business establishments and now includes all of the protected classifications that appear in the Fair Employment and Housing Act. Section 51 of the California Civil Code was amended in 2015 to extend the protections of the UNRRA Civil Rights Act to all individuals regardless of citizenship, primary language, or immigration status. The provision of services or documents in a language other than English is not specifically required by this law. Sections 54-55.1 of the California Civil Code prohibit discrimination in the rental, leasing, or sale of housing accommodations against anyone in one of the Fair Employment and Housing Act protected classifications. Discrimination in lending. The Federal Fair Housing Act prohibits discrimination in mortgage lending based on certain classifications. Prohibited activities include refusal to make a mortgage loan, refusal to provide information regarding loans, imposing different conditions, fees, loan points, or interest rates, discrimination in appraising property, and refusal to purchase a loan or setting of different terms or conditions for purchasing a loan. Information in a complaint form can be found at the HUD website by entering housing discrimination in the search box at the top of the page. In addition to federal requirements, state licensed savings and loan associations are subject to state regulations and guidelines adopted in 1976 that prohibit redlining. Redlining is the practice of rejecting real estate loan applications because of the location of the property involved. The state prohibition applies to all loans for the financing of dwellings of 1 to 4 units, including conventional, FHA insured, and VA guaranteed loans. As of January 1, 1978, California's Housing Financial Discrimination Act, the Holden Act, prohibits all financial institutions from discriminating in real estate loan decisions based on the geographic location, the neighborhood, or another characteristic of the property. Unless such a decision can be shown to be based on sound business practice, all loans on owner-occupied dwellings of 1 to 4 units, whether for purchase, construction, repair, remodeling, or refinancing, are included. The law also applies to secured home improvement loans from a financial institution, even if the property is not to be owner-occupied. Including the individuals protected by FEHA, the Holden Act provides that there may be no consideration of race, color, religion, sex, sexual orientation, marital status, national origin, ancestry, familial status, disability, physical or mental, medical condition, source of income or conditions, characteristics or trends in the neighborhood or geographic area surrounding the subject property. Complaints of violations of the Housing Financial Discrimination Act may be brought to the Secretary of the California State Transportation Agency, formerly the Business, Transportation, and Housing Agency, who has 30 days to act on the complaint. Various remedies are available in the event discrimination is found, including granting of the loan, granting of more favorable loan terms, or requiring payment of damages of up to $1,000. Decisions of the Secretary may be appealed to the Office of Administrative Hearings and from that body to a court. Lenders must notify loan applicants of both the existence of the law and the complaint procedure. Summary. Using its power of eminent domain, a government can procure property by condemnation in exchange for the property's fair market value. Federal involvement requires relocation assistance for displaced property owners and tenants. In an inverse condemnation action, a property owner complains that the value of property is impaired by the government's use of other property. The power of eminent domain involves a taking of property. A government can use its police power to regulate property use and is not required to compensate the owner for any resulting loss in value. The general plan, or master plan, establishes the development policies and goals of a city or county. The specific plan goes even further in defining desired population density and building intensity. Zoning is the primary form of land use regulation. A conditional use permit or zoning variance may be sought if a non-conforming use is desired. A community redevelopment agency was allowed to act as a developer would in refurbishing and rebuilding dilapidated residential buildings. Financing was repaid through tax increment funding or mortgage revenue bonds. The Subdivided Lands Law provides for issuance by the Real Estate Commissioner of a public report on the subdivision and available financing. A conditional public report allows property reservations even before a final public report is issued by the Commissioner. The Subdivision Map Act establishes minimum subdivision approval standards, which are elaborated on by local ordinances. Besides the subdivision map, an environmental impact report may be necessary. Special consideration will be given to property in an earthquake fault zone, seismic hazard zone, or coastal zone. Discrimination in housing and business establishments is strictly prohibited by both federal and state law. Fair housing protections also cover mortgage lending. Financing cannot be based on discriminatory practices such as the redlining of certain areas as unsuitable for loans. Open for discussion. Find out the zoning classifications in your city or county and compare them with those of nearby areas. If you could eliminate one regulation affecting land use, what would it be? If you had to create one new regulation affecting land use, what would it be?